Entrepreneur's Toolkit, Intellectual Property Series, Fundamentals of IP. We just want to quickly do a land acknowledgement. The UC San Diego community holds great respect for the land and the original people of the area where our campus is located. The university was built on the unprecedented territory of the Kumeyaay Nation. Today, the Kumeyaay people continue to maintain their political sovereignty and cultural traditions as vital members of the San Diego community. We're honored to share this space with them, and we thank them for their stewardship. Before we get started, we just wanted to let everyone know Startup Tree is a great way for not only the student entrepreneurial community, but the UC San Diego community to get connected to jobs, mentorship, fellow student entrepreneurs, other faculty and entrepreneurs, as well as mentorship. So that is something that if you want to check out afterwards, it's just at ucsd.startuptree.co. I'm going to stop sharing now, but I am going to put up the slide, and we're going to have Andre, who is one of our team members from the Office of Innovation and Commercialization, introduce our speaker, Ross Epstein.
Hi, I'm Andre Chikolsko. I work for Office of Innovation and Commercialization, and it's my pleasure today to introduce Mr. Epstein, who is a legal advisor of a wide array of clients, including US, European, and Asian multinational corporations. He is a partner in a law firm in San Diego. He is a partner at InteLink Law Group, and he has a unique affinity for entrepreneurship client due to his hands-on experience in business and as a founder and CEO of BSH Communications. He has developed BSH Communications into multi-million-dollar communication internet business, and also he worked in an in-house counsel role. With this introduction, Ross Epstein, please take over.
Okay, thank you, Andre. Let me grab my presentation.
And there was one question. This recording is going to be available on our YouTube channel. I will actually send that out after the presentation.
Okay, so you ready to go then?
We are ready.
All right. Hello, morning, everyone. As Andre said, I'm Ross Epstein. I'm a partner at InteLink Law Group. I'm going to go through this particular agenda. I'm going to start with, what actual intellectual property is. And for those of you who already know this information, feel free to ignore this part. But I think for a lot of people, this is the basics foundation for what we're going to talk about. Then I'm going to get into how you create an IP culture within your business, which I think is something a lot of people don't think about, but I think it's an important part of the whole process. And then talk about infringement, which is when people violate your IP rights, which again is something that's really important in the overall process to at least have some understanding of how it works. And last but not least, I'm going to talk about how you monetize your IP assets. These are things that should have substantial value in your businesses, and there are certain ways to go about doing this that basically leverage those rights in very practical ways. I'm going to start with a little bit more specifics about InteLink Law Group itself. It's an international law firm moving towards full service. And by that, I mean, we do a lot of different things for a lot of different companies, but not everything for everyone. The strengths of the firm are essentially three pillars. There's the intellectual property pillar, which is very strong in terms of intellectual property prosecution, which is patent, trademarks, copyrights, getting them through the Patent and Trademark Office. We have a very strong corporate transactional practice, which is corporate formation and structuring, mergers and acquisition, helping companies capital raise, all those sort of things that happen in the life cycle of a business. And then litigation is another one of our strengths, both domestically and internationally, if there is a problem, those things that we do. But we do have a number of other areas that are not specific to these three pillars that are also very interesting. We do immigration work, we do employment work, but we don't do things like taking a company public. That's not something we do. So as an example, we don't do bankruptcy work yet, although we are hoping to move into some of those areas as time goes by. My particular practice is a mix of intellectual property and corporate transactional work, which means that I work with patents, trademarks, and copyrights. I form companies, I help companies raise money, I do mergers and acquisitions, just we don't take them public. So my particular history, you heard a little bit about that from Andre in the introduction. I've been an IP and business attorney for the last 20 years here in San Diego. Prior to that, I was in Central Eastern Europe, in Prague and Warsaw for 9 years. Right after the wall came down in Berlin, I went there to get involved and wound up starting a telecom company, which kept me there for far longer than I ever expected. And if anyone's really interested in that, we can get together offline when we can get together face to face, a few beers, and I'll tell you lots of very interesting stories about what life was like in Prague and Warsaw in those days. And before that, I was a business litigator here in San Diego for 5 years working for a big law firm. So I've had a relatively unusual career path, which has led to quite a lot of interesting experiences, and I think a lot of value to bring to companies that I work with. So to get started on the intellectual property side of the presentation, just one piece of logistics. There may be questions that come up throughout my presentation. In a normal setting, I would open it up to people asking questions. Obviously, in a Zoom presentation, it's hard to do that with any kind of manageability. So if you do have questions, there are people, I think Gwen and Rachel are fielding them in chat. And at the end of my presentation, and then Andre is going to follow me with something about the tech transfer office here at UCSD. We'll then go through some of those questions and answers at the end of the presentations. So again, in the chat, feel free to ask questions, and then they will sort of manage that process when we're all done. Okay, so on to the actual presentation. Convert information to advantage is a great way to think about intellectual property written large. All the things we're going to talk about, or I'm going to talk about today, involve taking this intangible thing and using it to your company's advantage. That's what all of this is about, and it's a nice way to capture the concept. Starting with patents, right? What is a patent? I mean, what are intellectual property rights? I'm sorry. There are generally 4 different categories. You have patents, trademarks, copyrights, and trade secrets. Now, there are variations on all 4 of these things, but this pretty much covers everything that there is. And we're going to talk about each one in turn, but it's not this broad list of 15, 20, 30 different things. This is basically it. So what is a patent? So one of the things about patents is a lot of people think that when you protect an invention with a patent, it gives you the right to do something with that invention. But it's actually a negative right, which is kind of counterintuitive. It gives you the right to stop other people from doing things, right? Not to actually use it. Although the implication, of course, is that because you can stop other people from doing it, you can do it yourself, which is absolutely true. A patent lasts for 20 years from the filing date. It is an intangible asset. And as a tool for defining markets, it helps you to create, carve out an area of the business world that nobody else can play in. And that's what I mean by a tool for defining markets. It's a very interesting opportunity. What is patentable? A question that comes up all the time. Compositions of matter, mix 2 things together and you've got a potential invention that is protectable, as long as it's never been done before. That's the other thing about patentability. It has to be something that's truly unique and never been done before. Devices, processes, including business processes, software patents, even though they are somewhat in the doghouse these days because of recent cases by the Supreme Court limiting what can be protected in the software area pretty significantly. And improvements, which means things that are improvements over things that have already been done. In this world, a tiny little sliver of improvement can have dramatic value, even though it's only a slight improvement. But it does have to be something unique in and of itself when you make that improvement. All right, next up is trade secrets, right? So trade secrets is something that you do in your business that is unique to your business, right? That nobody else really knows about. It's not generally known, right? And that you actually keep secret, right? It's a common law right it used to be a common law right only, a state right. Recently, 4 years ago, there was a Defend Trade Secrets Act passed, which created a federal trade secret act that you could also use to enforce your trade secrets. But generally, it means that when you do something that's unique to your business, you need to take affirmative steps to keep it secret, which means that you got to password protect it if it's on a computer. If it's a customer list, you put it in a drawer and lock the drawer. If it's that kind of a business, and there's no expiration for a trade secret. It can last forever as long as you treat it that way. But when you go to enforce it, it's something that you have to establish by showing a judge that you actually have taken affirmative steps to establish it as a trade secret. Oops, I think I just pressed the wrong button. Sorry about that. Next up are trademarks. Right? Now, trademarks are designed to protect a brand, right? Goods and services that are put into commerce. And what you're doing is you're basically building goodwill behind that product or service and that name that's associated with the product or service. Right? That's why trademarks have value. It can be a word, it can be a symbol, color, sound, packaging. All those things are within the scope of of trademark protection. Right? It's defined by, and the scope of those rights are based on how you describe what it is that you are protecting under the mark, which actually in a trademark application, you list out the products or the services that are associated with the trademark. And again, like a copyright, like a trade secret, a trademark can last indefinitely as long as you're using it. And every 5 years, and then every 10 years, you actually have to show the trademark office that you're using it by filing what's called a statement of use. And that's an example of how you're using it in commerce, and that can allow that trademark to go on indefinitely. Okay, moving on. So copyrights, the last category of intellectual property rights. So this is the concept is one where you reduce an idea into tangible form, right? And what that means, a great example that I like to use is a photograph of a sunset. The sunset itself clearly is not copyrightable, but the photograph that you take as the photographer does reduce that concept into a tangible form, and the tangible form is the photograph, right? And as the author, quote unquote author, the photographer, right, that trademark, that copyright lasts for as long as you live, plus 70 years, right? And that number, 70 years, has been increasing over the years because of Walt Disney and Mickey Mouse, believe it or not. So Mickey Mouse was about to expire, and the Congress of the US decided, well, we want to keep that national mark, we want to meet that national copyright and protect it for Disney. Disney did a lot of lobbying, and suddenly they passed an extension. Instead of 50 years, it became 70 years. So the next time the Mickey Mouse copyright is about to expire, keep an eye out for what Congress does if they decide to extend it again. We'll see. So copyrights are involved in music, art, film, all these different lists. In the UCSD world, copyrights are probably most prominent in software development, because when you write code, that code is the reduction of that concept of whatever the code is about to do into a tangible form, and that's where copyrights attach. Right? This presentation, because I'm the author, I put the copyright symbol next to the year and my name because I own this particular presentation.
So Ross, there's a question. Can you talk about copywriting a CAD file?
I'm not sure. Well, copyrighting a CAD file is, again, the CAD file itself is a reduction of an idea, whatever is describing, right? And so that file, in and of itself, copyrights attach, owned by whoever created it, if that answers the question. I hope. But this is the problem with these questions. I don't know who asked it, and I'm not sure exactly how to answer it. And so if we hold them to the end, I think that would be best. Okay?
Got it.
All right. Moving on to how to create an IP culture within your business. So the first thing when it comes to patents is to keep inventions secret. And the reason for this is because if you disclose or publish, the term of art is called publishing. an invention, which means that you put it into the public domain in some way, shape, or form. In the university setting, oftentimes it's an academic paper put out by a professor who does research. And before that professor puts out the paper, if you don't file something, then once you put it into the public domain, most of the rest of the world operates on what's called an absolute novelty basis, which means that once you disclose an invention, you can't protect it. In the US, we have a 1-year grace period. The statute of limitations is triggered from the day that that is disclosed to the world in order to file to protect it. All right, so generally speaking, in the world of research and development, you want to keep your inventions secret until you know for sure how you're going to treat them, right? Are you going to keep them as trade secrets and then you have to keep them secret for the indefinite future? Or are you going to file a patent application to protect the invention, right? And at that point, you have at least potential rights, because there's no guarantee that a patent application will ever turn into an actual patent. But you have looked after your rights carefully, right? Because if you don't be careful with that, you can lose international rights for sure. And if you wind up disclosing it more than a year before you file, then you can lose your US rights as well. So the idea internally is to make sure that your research and development people understand the need to keep things secret and to only disclose under the right circumstances. Having NDAs in place and other secrecy agreements are just fine to keep the invention secret. So you can disclose under those types of agreements because that will suffice as not to be a publication, right? You're not putting it in the public domain. In that case, you're disclosing it only under a very carefully controlled situation, and that's fine. In anticipation of maybe a question about that. Okay. So internally, right, why is it important to create an internal IP culture? Because that's how you figure out what your foundation technology is and you continue to develop it. Non-disclosure agreements should be used every time, even if you have filed for protection, you still want to use non-disclosure agreements, secrecy agreements, confidentiality agreements. It's just good practice in general. That way, if something actually has not been filed, you still have that agreement in place and you haven't actually published it, you don't lose any rights. Employment agreements are really important to make sure that your employees understand that this company cares about intellectual property rights and that anything that they do is going to be automatically assigned to the company, right? Employee handbooks are also part of that as well, to make sure that in those documents, employees understand that whatever is being done in the process of them doing their jobs is going to be owned by the company. You want to interview your inventors if you have a team of inventors to make sure that you're constantly mining what they're doing for potential patent applications. There is a general rule out in the world, and we'll talk about this when we talk about monetizing IP rights, that more is better. If you have more patents, you have more value in your company, you have more opportunities to monetize, better protection, better position in the market. And that's a general rule. Of course, the patents themselves have to actually be valuable. Keeping and monitoring laboratory notebooks. This is a really important thing that a lot of people don't think about much, but if you record carefully all the things that you're doing, it's a really good way, best practice, to make sure that those valuable inventions don't get lost. It used to be a critical element, which we'll talk about in a little bit, about how it is that it used to be the way that you decided whether or not you had patent rights versus somebody else had patent rights. We'll get to that in a minute. But just as a good practice internally for those people who are doing research and development work, keeping laboratory notebooks is really important. That way you have a record of what's been done. When it comes time to turn it into what's called a patent disclosure, you have all the information or invention disclosure, excuse me. You have what you need to create that in an efficient way. Registering your branded trade names, right? One of the things we didn't talk about when I talked about trademarks is that can be a common law right as well as a registered trademark, which is nationally protected or even protected at the state level, right? But again, internally, making sure you recognize what it is you're doing, how it is you're describing your products and services, and thinking about whether or not this is something that you should protect, whether it's local, whether it's a state, whether it's federal, and then of course international as well. Copyrights need to be registered in order to be enforced. They do exist when the work is created, whatever that work might be. But in order to enforce them, you have to actually register them with the Copyright Office. And unlike patents and trademarks, which you can only get protection in the country where you register, file a patent application, file a trademark application, you have only rights in the US if that's where you do it, nowhere else in the world unless you go to those countries to ultimately pursue those rights. Copyrights, on the other hand, through a series of international treaties, are enforceable everywhere, but you need to register them at least in the US. And then last but not least, trade secrets, you need to treat them like secrets. Again, in the employee handbook is an important place for that information to be disclosed to your employees. The most frequent time this comes up is when one of your employees moves to one of your competitors and they take one of your trade secrets with them, right? One of the few times in California, at least, where you can actually enforce, it's not really a non-compete, but it is a way to get somebody to stop working for somebody else if you can prove that you had trade secrets and that person left with them. There was a famous case just recently. This can be a criminal case or civil case. A guy who used to work at, I think it was at Uber, moved to another company in the Bay Area and took their self-driving vehicle technology with him. That guy has been indicted and is in deep trouble because that's how serious theft of trade secrets can be. All right, laboratory notebooks. I want to talk a little bit more about these. All right, as I said, they are a way of recording the ideas that are being researched and developed within your business. They help create company value. They should be kept as trade secrets until and unless you file a patent application of some kind, right? And as I mentioned before, at one time, that was how you determined who actually owned a particular invention that was being protected, that was being patented. There was a rule up until 2013 that the first to invent was the owner of a particular patent. Famously, Alexander Graham Bell had this exact situation come up in the 1800s when he invented the telephone, and nobody knows who the other guy is because he was able to establish that he was the first to invent the telephone, right? Recently, in order to harmonize, quote unquote, harmonize the rest of the world, and we talked about this a little bit earlier, the rules were changed to the first to file. So now if somebody else files before you do on the same invention or somebody that's really close to what you have, they own the patent rights and you're out of luck. Geez, I did that again. Okay. Another important thing to do internally when it comes to IP is to monitor your competition. You should be using these things to know what it is your competitors are doing. Doing regular IP searches for competitive technology, which means going to the Patent and Trademark Office and learning how to search through the patent database just to get an idea of the people that are in the same space you're in and what they're doing, right? It then allows you to modify and develop your own business goals in a way that takes into account what the competition is doing, both technologically, and oftentimes you can understand what they're doing from a strategic standpoint as well. It then allows you then again to incorporate that important intelligence into how you develop your own IP strategy for the development of your portfolio. A lot of times the way I describe what I do when it comes to patents and trademarks is develop and manage IP portfolios, patent and trademark portfolios, because it is an ongoing process and should be. If your business is an IP-based business, right, then you should be thinking about things this way and strategically approaching IP as a way of incorporating it into your overall business, which is again, all part of this, creating a culture within your company to do this sort of thing. We regularly do training sessions with our clients on how to do that, how to get engineers or scientists to think about intellectual property rights. On the engineering side in particular, there's always this tension between collaboration and private, protecting proprietary information. The open source movement is exactly that thing. And so it's important to keep those in mind as you go through the process and explain and educate your people on why it matters to keep things secret, on why it matters to keep good notebooks, and why it matters to think about what they're doing and how it ultimately might benefit the company. And also you want to develop incentive plans within the company to get people to do the things you want them to do. Awards don't have to be money. Oftentimes, all people want are recognition, and all that's part of the process of creating an IP culture. All right, so protecting IP externally, right? The foreign patent and trademark rights are different, but very similar to what we do in the US. But there are really important deadlines that come up over time. Many of you have had patent rights, probably have dealt with this already. Generally speaking, within 1 year of your initial filing date, you've got to at least file what's called a patent cooperation treaty application in order to preserve your international rights, assuming that you haven't already published your invention prior to filing to begin with. Okay. There are very early strategic actions that are really important. Provisional patent applications are oftentimes used, especially with startup businesses, because they're less expensive and you're not sure exactly where the research is going to go. And this original application may or may not be what you ultimately turn into what's called a non-provisional application, because whatever you're doing has moved on from that, and the value that you thought was in the original filing just isn't there anymore. And that's fine, because this stays secret for at least a year. Provisional patent applications do. And if you don't do anything with them, they'll expire and go away and stay secret forever. Licensing is also another important aspect we'll talk about more later, but just to consider how you deal with your intellectual property assets. And then to think about infringement strategies. Am I infringing somebody else's patent? Is somebody else infringing my patent? Are my trademarks being infringed because somebody with a similar product is using a similar name and people are getting confused? And we'll talk about what infringement looks like in a second. And there it is, infringement. So each one of these intellectual property assets that we've been talking about have their own infringement rules on whether or not another company or another person is actually illegally using your IP rights. Starting out with patents, right? So many of you have probably seen a patent application or an issued patent, and you will see that every one of those patents or patent applications has a specification part of the patent or the patent application where it explains what the invention is, and then a set of claims, right? Which are really arcane language that only lawyers really understand, that describe what it is that you've carved out in the world that you own, right? The claims basically tell us what it is exactly that you own. And so in order to have infringement, when somebody has a product or is doing something that would infringe your patent, each element of every claim needs to describe what that thing is. If there's something about, if there's a part of the claim that doesn't describe the thing you think is infringing, then there is no infringement. The only way you can get beyond that is if you have the doctrine of equivalency, which basically applies under certain circumstances. Getting into what unamended claims are and all that sort of thing doesn't make a lot of sense given the time that we have. But that's one way to extend a little bit beyond what the description is if it's close enough to cover it, right? And your damages, if you actually are able to prove infringement, are lost profits, and possibly, if it's intentional, triple damages and attorney's fees. That's for willfulness. For trademark infringement, right? The key is that the mark that's being used to sell goods and services that are close to yours would create a likelihood of confusion as to the source of the product or service. Right? That is the definition of trademark infringement. And the way that you prove that is typically doing consumer surveys, where you basically show the two marks side by side and you ask, would this be something that you would be confused about if you saw it and you wouldn't know which one was which? Right? So that's how you prove trademark infringement. Copyright infringement is essentially illegal copying and distributing of a protected work, right? So if that photograph that I mentioned earlier of the sunset was something that you owned and somebody else got a hold of it, made copies, and were selling it and distributing it, that's infringement. They're very narrow, these rights, and infringement has to be the exact thing. If somebody else was standing next to you and took their own picture of the same sunset, then you have no way of stopping them from distributing and copying that work because that's their work, not your work. So as you can see, it's a very narrow type of protection. And you can do all these different things: injunctions, impound, damages, attorney fees. It can be criminal, right? And if you file for protection, if you file for copyright registration early, you have a number of statutory damages where you don't actually have to prove your damages. That's one of the values of filing early. After a certain period of time, you can register your copyright anyway, but then you have to prove your damages as opposed to getting the statutory damages, which can be $750,000 to $30,000 per work and $150,000 per copy if it's willful. So there's some very powerful rights here, but they're very narrow rights. Theft of trade secrets. We talked a little bit about this before. These are typically civil actions. Sometimes they're criminal actions. It comes up when a key employee goes to a competitor and takes your trade secrets with them and makes that competitor more competitive at your expense. And it kind of represents, as I mentioned before, an alternative to non-compete actions. But you've got to be able to prove that you have established it as a trade secret, which means taking those internal steps. Think of it as internal controls on who has access to these valuable things that you call trade secrets. And if you take those steps, then you can establish that it is a trade secret. And if you can prove that an employee left and took it with them and is now a competitor is using it, you have your cause of action. All right, so moving on to the monetization of IP assets. You're investing, good way to think about intellectual property when you are pursuing those rights is you're making an investment in your business, right? And that investment should ultimately bring you a return. And that return can look like a number of different things. So one is enforcement, right? It gives you a competitive advantage and you can stop other people from using that invention. You can stop other people from using that trademark. You can stop other people from using that copyright or that trade secret. It gives you a competitive advantage in the marketplace so you can actually clear the slate of any competitors in your area where you have protected it. Licensing is another area where you can actually create value for your company because you can create alternative revenue streams by giving people permission to use your intellectual property rights, whatever they may be. They can all generate ultimately license fees, which is if you have rights in a particular area, it's not your core, but you've still protected it, you can license it out and create an alternate license revenue stream while you're still pursuing your core business. And then of course, if you're successful at enforcing the rights, you can collect damages. So when it comes to licensing, and Andre is going to talk a little bit more about this when I'm done on how the university does this. Generally speaking, there are many, many terms that go into licensing, but some of the key terms of a license agreement have to do with royalties, right? Which are actually what people pay when you give them permission to use your IP, right? And it can be anything from a fixed number, it can be a percentage, it can be defined by net profits, gross revenue, net revenue, all kinds of different things. These are all the issues that come up in a negotiation for a license agreement. And that's what royalties are. Is it going to be an exclusive license or is it going to be non-exclusive, which means that only that licensee can do whatever it is you've given them permission to use, including if it's fully exclusive, you can't do it yourself if you license it out that way. Non-exclusive licenses then allow you to do it multiple times with several different licensees. You can do it yourself. There's no restriction. And then it's just a question of managing all that. And fields of use are areas that people don't really think about very much, but they can be the areas where you have a broad application of a particular type of intellectual property, and you can define the world and carve it up into fields of use so that you give an exclusive license for a certain vertical industry and reserve everything else for yourself, right? Or you can create territories, physical territories, like by state, country by country. There are all kinds of ways of carving up your intellectual property rights, which then go into a license agreement and fields of use. And again, as I said, Andre will talk a little bit more about how the university does that. So increasing the value of your enterprise. This is also an important part. When you have, like I said, more is better. So the more patents, the more trademarks, the more copyrights, the greater the value of your enterprise will be. It helps when you're raising capital. It helps when you're selling on an exit. It can be security for debt. and it creates all kinds of mergers and acquisition opportunities. So there are a lot of values that IP can create within your business. International markets, again, exporting, manufacturing abroad, and counterfeiting. Right? The world is full of counterfeits. It's a whole other area of importance, which we can't get to today. But when somebody is knocking off your product and selling it in the US, you want to have something you can do about that. There are tax advantages that come into play when you talk about intellectual property rights. Research tax credits, structuring IP holding companies fell into disfavor under the new tax law, but may be rising again with the new administration. And as we talked about, licensing structures come into that as well. So to finish up, and I know I've run over a little bit, we're about 40 minutes in, I wanted to talk a little bit about the UCSD sponsorship that InteLink has with startup companies. So we have committed $100,000 this year and last year in legal work for UCSD undergrads, graduate students, and alumni. Right? This link here is how you can get to the application, right? And so far, you can see the list of companies that we've been working with that are startups at UCSD. And that is available for anyone who's interested. I think through the startup tree is how you sign up for, I have office hours every Monday. If you're interested to talk about things, that first interview or first office hour discussion is not charged, of course, to get an idea of what it is you need. And then once we talk about it and you're interested, you can go through the university to get ahead of all these sponsorships. And at that point, we can start working with you on a deeply discounted basis. That's it for me. This is my contact information, our website, my phone number, and my email address. Hopefully that can be distributed if anyone needs it. All right, that's it for me. Andre, are you ready?
Yes, I'm ready, and thank you so much for your presentation. And this is really a valuable introduction to intellectual property. And, being a former postdoc and researcher at UC, I would always appreciate this kind of an introduction while I was on the research side, because as a researcher, I was pretty naive in terms of intellectual property. And I think this is kind of mandatory for all researchers, students, postdocs, and young faculty to hear this kind of presentation early enough not to make any mistakes about intellectual property and contribute to university success. So if I may, I have a very quick overview of our office, and then we can go back to the questions. So if I can share the screen, I believe.
Yeah, I took mine down, so you should be good to go.
Yes, I believe I can. Yes. So here, can everyone see my presentation?
Yes.
Okay, very good. So our Office of Innovation and Commercialization at San Diego is under general category of technology transfer, but this is not more than just technology transfer. We deal with inventions, we deal with copyrights, we deal with innovations. We don't deal with trade secrets as much because we are not corporate world and we at university need to publish, but we deal with all kinds of intellectual property. And here is a link to our portal, innovation.ucsd.edu. And under this portal, we have 3 entryways, one for undergraduates and graduate students. And there is a difference between undergraduates and graduates in terms of ownership of intellectual property. Normally, undergraduates own their inventions, and graduate students, if they are paid by the university, they need to assign their inventions to the university. Then there is an entryway for faculty, for researchers, and university employees. University, through the employment, owns intellectual property, owns rights to inventions, right to patents, from their employees, from their professors and researchers alike. And we commercialize those inventions. And then there is another portal for alumni, for industry, and for community. So depending on who you are, you can go to our office and you will be directed to proper personnel and you will be given instructions what to do. So our mission and our vision is to be the world's most innovative university, and we create economic and social prosperity by using research results, by using innovations, by using inventions. And here is kind of a complicated schematic of innovation and commercialization loop. It starts with research. Research generates inventions and discoveries. Those discoveries and inventions are disclosed to our office. It's important, as Ross mentioned, to disclose them early before publishing so we can make an assessment about possible patent protection. We can assess novelty and potential obligations to sponsors, federal, state, and private organizations, companies, foundations, and such. Then we decide if the invention is worth patenting, and we do patent filing. Once we do patent filing, once we go with patent protection, we market inventions for purposes of commercialization. And if it is justifiable, we help inventors, faculties, researchers, graduate students to start their own startup companies. We'll license the inventions for purposes of development and further deployment. And when the loop goes back from the benefits of research, we get also payments to the university in forms of royalties, in terms of economic and social benefits, by creating new jobs, by creating new inventions that make human life better, by getting back money in terms of donations and sponsorship to further research, and that loop goes on and on. One of our missions is to assist in open flow innovation, to remove barriers in tech transfer, to streamline and simplify legal agreements that are very important for commercialization, help startup companies. One of the big programs created recently is that we have streamlined express licenses where we only take 5% equity from university-driven startups and nothing else, no fees, no future royalties. And that's very important because startups usually don't have cash at the beginning, but they do have equity. So it is very advantageous for them. We help them, we'll license our technologies to them exclusively and create unique position in the market. And in exchange, we get a fair share from company equity. But we also deal with large companies where we get royalties, milestone payments, and such. Our office has two teams, physical sciences and life sciences. So depending on what is the scope of your research, who you are, you will be dealing with physical sciences or with life sciences. And quite often those fields actually interfere and intervene, and we can do a teamwork assessment of your inventions. Here is the list of contacts, and depending on your field, you will have a designated ICM, Innovation and Commercialization Manager, to work with. And a few slides to brag about our innovation. On a previous slide, it mentioned that you see San Diego researchers create more than 400 new inventions, copyrights, and tangible research materials each year. This is really, really big number. So this is number of disclosures, consistent, big number of inventions and copyrights and tangible research matters throughout the years. more than 400 inventions and copyrightable disclosures each year. And a lot of them are patentable. We see number of US patents being issued. That number doesn't really go up linearly because patent office, sometimes it's slower, sometimes it has certain delays, sometimes it has certain streamlined procedures, but it is consistent. Every year we have more than 100 patents being issued. Sometimes it's more than 100. And if you compare the numbers throughout the entire university, you see San Diego is usually number 2, number 3, sometimes number 1, along with such big campuses as UCLA or UC San Francisco or UC Berkeley. We are always on the top. And as far as licenses to inventions and copyrights, those numbers steadily grow with years, and as well as new startup companies. We create more than a dozen, more than 20 companies at each given year, and we support them in all possible ways to provide them legal support, to provide them also with streamlined licenses, and if necessary, with incubator space and such. And here is just a little piece of statistics, how we are compared to other big universities nationwide. Of course, this statistics is lagging a little bit, but we see that in 2017, 2018, our campus alone, not entire UC system, but our campus alone was number 2, number 3 nationwide in terms of creation of the startup companies. With that, I'm happy to go back to the question and answers, and because it's recorded, you can always find our contact information. So thank you very much. With this, I will stop sharing the screen. And Gwen or Gwen, you probably have questions and answers, right?
Sure. So one of the questions that we had, if a provisional patent expires from lack of action, is its content now available for others to see?
The answer is no. The answer is no. When it expires, it's kept, when you file a patent provisional application, it's really a placeholder. It sits in the patent office until and unless you convert it into a non-provisional application, which then gets into the queue for examination. And that non-provisional actually remains secret and not published or disclosed for another 12 months. So a total of 18 months goes by before any patent application is published, but they are eventually all published unless you have some sort of national security type invention, which then can remain confidential. But a provisional application that's never done anything expires, it just goes away as if it had never been filed at all. The one danger though is if you do disclose the invention during the pendency of that 1 year, then you trigger the statute if you let it expire, and you have 1 year from that date to actually file another application to protect it in the US, and you may have lost your international rights.
Okay, so next question. If someone else files a patent on an invention based on what you disclosed to them under NDA, how do you go about providing violation if the disclosure was verbal? Or proving violation, sorry, I can't read.
All right, so this would be, well, first of all, the NDA will have provisions for enforcement in it, or at least it should, right? And then it's a question of proving that you disclosed to that person and that person then did what they did. I mean, this is how lawsuits work. You present evidence, and it may come down to, a he said, she said kind of situation. And then it's a question of who do you believe, right? And that's part of it. But the idea is if that person has signed an NDA and has then gone ahead and filed something that you can prove that you actually were working on, it'd be hard to avoid the conclusion that that person stole it.
And let me add also to that, that when we sign NDAs, and this is what our office does, we do sign NDAs very often on behalf of the university, we always say that the confidential information should be labeled as such, either prior to information exchange or within, let's say, 30 days after the disclosure was done. Otherwise, it's not considered confidential. So if the exchange of information was verbal and it was never confirmed later as confidential by email, by written communication, then it's not considered confidential. So how do you enforce it if it was not labeled as confidential? In other words, you know, a verbal agreement is worth less than a paper is written on. So if you don't have anything written, then it is very difficult to enforce.
Okay, next question. If you license a product which initially has no exclusivity and later on the owner includes exclusivity as part of an update in a disclosure, such as comments in a download, what are the limitations imposed?
Okay, that's a complicated question. I'm not sure I understand. Can you read it again?
If you license a product which initially has no exclusivity and later the owner includes exclusivity as part of an update in a disclosure, such as comments in a download, what are the limitations imposed?
Okay, I think I understand the question, but I'll sort of rephrase it. So originally you license rights that are non-exclusive, and then in a later communication, the licensor says that it is exclusive. If I think I understand the comment. Typically, a license agreement will have provisions in it that have very specific ways of essentially amending the license agreement, which would be the way that you would change it. And so while it may be you may have an argument as a licensee that the owner intended to give you exclusivity, it'd be hard to enforce that without some sort of formal amendment to the original agreement that both sides sign. So it's unlikely that later download where they said it was exclusive would necessarily be enforceable.
And also let me add to that, who is the owner in this case? If we're talking about university and a license from university, then university is the owner. I just want to make a distinction that if the professor or researcher invented something and gave it to our office, it is the university who decides whether it's better to license it exclusively or non-exclusively, depending on the technology. And the inventor may have certain views. Inventor may say, let's share it with the whole world, or let's give it exclusively to the company I like. University not necessarily will follow what the inventor wants because it's a university intellectual property, not the inventor's one. And it may sound a little bit difficult for the inventor, but that's what it is. University owns the intellectual property and university makes the decision about exclusive licensing or non-exclusive licensing, what's better for the society, what's better for university, not necessarily what's better for individual inventor.
Okay, so next question. If I'm graduating soon as a PhD student and will be starting a company, can I still take advantage of the 100K sponsorship?
Yes, it is for alumni as well as for current graduate and undergraduate students. So the simple answer is yes. The application process starts through that link that I had on my presentation. There is a limit. I believe the limit is $10,000 per applicant. So it's not all for one, but that is that is determined by how much you need and a negotiating process with the Office of Innovation and Commercialization.
Okay, so we're almost at time. So maybe one last question. When does a patent get triggered? Is there a percentage overlap in similarities between products or software?
If you mean when is a patent infringed, which I'll interpret that question to mean when is it infringed, As I mentioned in the presentation, and I know it's fairly complicated, the patent claim that's been issued by the Patent Office has to describe the thing that the alleged infringer is doing or making completely. So every claim, at least one claim, every aspect, every part of that claim has to describe what's being done, and that's when you have infringement. It's a complicated process, so not easy to explain or answer in a situation like this, but that's how it works in general.
Thank you. So I guess Andre will have some closing remarks.
Well, I just want to thank everyone for attending this webinar. And if you missed anything, the recording is available. And if you have any questions, you can always ask these questions either to our office or to Ross. We can definitely be helpful. And nowadays it is because of the isolation, because of the pandemics. I cannot say that my office to my door is always open because I cannot get to the office. We cannot get to the office until our offices until the end of May, but we can always answer emails and we can always provide consultations on a Zoom chat. And again, thank you very much for attending the seminar.